go again. I'm not paying you, mate. You are. I'm not paying you. Do you want to know who we are? I don't bother who you are, mate. Good start. I'm paying for the balance. Really, that's
Hello, everyone. This is Ava Satori. I'm on the Education Committee and Board of WICRM. We will start the meeting in a couple of minutes. We just want to be sure everyone has a chance to sign in. I put a message for everyone that if, obviously mute yourselves if you're not presenting. If your name doesn't appear completely, if it doesn't appear, just email Talia at Fox Ballard, and I gave that email address. So we'll just allow people to sign in and we'll start the meeting. Thank you.
Dang.
All right, we're going to go ahead and start the meeting. Others may still join us. I have the pleasure of introducing our two presenters today. Aida Babametovic practices medical malpractice defense law at the firm of Johnson, Graff, Key, Moniz, and Wick in Seattle, Washington. Aida's interest in dynamic healthcare industry brought her to the Pacific Northwest, where she worked as a corporate counsel for an emerging clinical education technology startup. Aida has diverse experience in defense litigation, business transactions, and healthcare regulation and corporate compliance, having worked in those spaces since graduating law school in 2012. She is licensed to practice law in Kentucky, Washington, and Alaska. And the next presenter is Bisma Shoab. She is a civil litigator with Johnson, Graf, Key, Moniz, and Wick, also in Seattle, focusing on healthcare litigation, regulatory compliance, corporate governance, and health information privacy. With a diverse background in policy work and experience, serving clients across international landscapes, she brings a unique perspective to her practice. Bisma is licensed to practice law in the state of Washington. And without further delay, I'm turning this over to Aida and Bisma. Thank you.
Thank you so much for that introduction, Ava. Thanks for joining us this afternoon for this presentation. Over the next hour, we will be discussing topics along the lines of the Washington Department of Health investigations and some of the new regulations that have come out regarding reporting requirements, both for license holders as well as employees, employers and healthcare institutions. I will be presenting along with my colleague, Bisma Schwab. We both work at the law firm of Johnson, Graf, Key, Moniz, and Wick here in Seattle, defending healthcare providers in mostly medical malpractice cases, but we also conduct representation of license holders for Department of Health investigations. So we'll be presenting with the perspective of defense attorneys who assist healthcare providers in the process of investigations and the disciplinary process, as well as consulting healthcare institutions and hospitals during the reporting requirements. As far as today's topics that we'll be covering in the agenda, I'll turn over the presentation to Bisma, who's going to talk about the general overview of the Department of Health and the statutory scheme that governs the Department of Health and its authority. I will then briefly cover the complaint and the disciplinary process with the Department of Health and the life cycle of a complaint through resolution. Bisma will then cover the reporting requirements under the Washington Administrative Code. Like I said, that recently or relatively recently came out both for self-reporting requirements for license holders and for employers and healthcare institutions. And then at the end of today's presentation, we'll go over a couple of case examples that discuss kind of the overview of the Department of Health investigations and reporting. If you have questions along the way during today's presentation, please feel free to share those with the organizers in the chat. We'll do our best to address as many questions as we can at the end of today's presentation, but you're also feel free to email us after today if you have any other questions or if we didn't cover any topics that you wanted us to expand upon. So with that being said, I will turn things over to Bisma to give you a general overview of the Department of Health.
Thanks so much, Aida, and thank you for the introduction, Ava. Appreciate everyone joining us today. So as Aida mentioned, I'll briefly define and explain what the Department of Health actually is and what jurisdiction it has. So it's a state agency headquartered in Olympia and offers comprehensive public health services and programs. It was formed to promote and protect public health, monitor healthcare costs, maintain standards for quality healthcare delivery, and also plan activities related to healthcare of citizens largely. So as the goal of the department sounds broad, its jurisdiction is also equally broad. Some of the things that the department does is rulemaking. and issuance of licenses, permits, certificates, and all of that comes into play under Title 18 and the Uniform Disciplinary Act. So it operates largely within those two statutory frameworks. Department of Health adopts rules according to its statutory authority, and it has to be consistent with the Administrative Procedures Act. We have the Secretary of Health, who is appointed by the governor, and the Secretary of Health enforces the laws that the Department of Health creates and has the authority to do so under Washington's statutory scheme. Since 2020, our Secretary of Health has been Dr. Umair Shah. You may have seen him presenting or talking about the new legislations that have come up. Can we have the next slide, please? So as I mentioned, the Department of Health has pretty broad jurisdiction, but it is divided into boards and commissions and advisory committees as well, which govern the governor or the Secretary of Health appoints the members of the boards, the commissions, and the advisory committees. So along with the State Department of Health, Washington's public health system includes 35 local health departments and local health districts, which cover and serve about 39 counties in Washington. Tribal governments and other partners also collaborate with the Department of Health, so it is truly a collaborative effort. The department itself collaborates with other state agencies whenever they're implicated, for example, the Washington State Human Rights Commission. So it doesn't operate in a silo. Then, as I mentioned, one of the things that the department does is issue licenses, permits, and certificates. It also has the authority to hold those license holders and professionals accountable. And all of that, again, is governed by Title 18. Some of the healthcare professionals, as you may know, might need a license or a permit or a certificate, and there are different pathways to that. For example, a speech therapist is regulated through a certification process. A nursing assistant may be registered or certified with the Department of Health. But what is consistent is that many practitioners licensed under Title 18 are directly accountable to the Secretary of Health for discipline and professional conduct. Others are disciplined by way of a board or a commission governing only one or a few categories of professionals and practitioners, depending on their specialization.
Okay, so as I mentioned, I was going to briefly go over the life cycle of a complaint and disciplinary process in the context of the Department of Health investigations. And
can you come in here and I'll.
And as I mentioned, as defense attorneys, we primarily get involved when there are active investigations of healthcare providers and licensee holders under the jurisdiction of the Department of Health and its various boards and disciplinary authorities. So once a report is made to the Department of Health, and regardless of who makes that report, whether it's a complaint filed by a patient or a self-report or an employer or malpractice settlement or judgment, the process is standardized across the various disciplinary boards and bodies through a law that has been enacted called the Uniform Disciplinary Act. That Uniform Disciplinary Act governs the licensure and disciplinary procedures for all healthcare professionals across the state. Therefore, the process for disciplinary actions and investigations is uniform across all of the various disciplinary bodies that are under the umbrella of the Department of Health. Once that report is made, then the Department of Health and its disciplinary bodies underneath it look at the merits of the complaint and determine whether an investigation is warranted or not, or whether there's merit to conduct an investigation. The things that they look at are pretty broad. First, they'll look at if it's an issue or a complaint that falls within its jurisdiction. And then they will look at whether the issue is of concerning public safety or public health. As you can imagine, anyone can log on to the website, the Department of Health website, and fill out a complaint. And they get many of them on a regular basis from the public. And some don't fall into the jurisdiction of the Department of Health, and some don't fall into the categories of public safety and public health. I think one of the most common issues that they see is patients or members of the public filing complaints on the basis of billing disputes, which is something that the Department of Health does not have jurisdiction to review. But other than that, it's a pretty low threshold, as long as the complaint covers license holder that is under the jurisdiction of the Department of Health, that the Department of Health issues licenses and credentials for, and as long as the issue that is being complained about or that is being raised to the Department of Health is one involving public health or public safety, then for the most part, the Department of Health will launch an investigation. Pretty low threshold. Once that investigation is launched, the Department of Health will assign an investigator to the case, and they issue a letter of notice to the licensee holder, letting them know that a complaint has been lodged. And usually the letter of notice has very little information about the substance of the complaint or the identity of the complainant, for a variety of reasons, including whistleblower protections. But this letter of notice is there for the license holder or the person that's being investigated to know that the complaint has been lodged, and therefore they can seek counsel. That letter of intent or the letter of notice also, generally speaking, does not require a response. A response is allowed most of the time, but generally is not required. And for our purposes, again, as defense attorneys who work with healthcare providers in these types of investigations, we generally don't advise responding to just a notice, since we don't have very much information, if any information, about what the investigation is about or what the allegations are, or what the complaint is about. So then the next step would be to get a follow-up letter from the Department of Health once they have conducted their initial investigation and formed whatever information they need to determine what the allegations are and identify what the allegations are. Then the Department of Health will issue a subsequent letter with outlining the claims or outlining the allegations of unprofessional conduct. Unprofessional conduct is actually statutorily defined under RCW 18.130.180. It's there on that slide if you want to jot that down. But there's a variety of actions or conduct that is considered unprofessional in Washington. The one we see most often are malpractice. So if there's a judgment, a trial, and a jury awards a judgment to a plaintiff or a patient for medical negligence, that's a form of unprofessional conduct that the Department of Health investigates. Same for malpractice settlements, as long as they're over $20,000. That's an example of unprofessional conduct that the Department of Health investigates. Other types of unprofessional conduct that's statutorily defined includes acts of moral turpitude, dishonesty, corruption relating to the practice of the person's profession, false advertising, misrepresentations or concealments of material facts in obtaining licenses. So lying on a credentialing application or making misrepresentation on a credentialing application, things like that. It's important to note that these crimes of moral turpitude or definitions of moral turpitude do not actually have to be criminal acts. It's enough to have actual knowledge or actual evidence of some form of dishonesty, some form of moral turpitude, some form of corruption. So once that letter with allegations for unprofessional conduct is sent to the license holder, then generally speaking, the Department of Health requests further information or a statement from that license holder. And that's where we come in as defense attorneys. Again, we help providers put together statements and responses to the allegations to the Department of Health. They often also require or seek additional information by way of records or business records from employers, personnel files, things like that. And so we kind of help gather all of that information. I want to note that in this letter that the Department of Health sends to the licensee, they often or always include a deadline, and those deadlines are very firm, generally speaking. We've seen in recent years, the Department of Health has really pushed back on requests for extensions, especially for reasons of scheduling, or I had an instance where I was representing a provider in a Department of Health investigation, and I was in trial during the time that we received the letter, and I told the investigator that I was in trial and asked for an extension, and the Department of Health denied it. So they've been pretty firm with their deadlines, and if we miss a deadline, if the licensee holder or license holder does not respond timely to a Department of Health request for information or request for statement, that in and of itself can be considered unprofessional conduct. So it's really important to meet the deadlines and pay attention to the deadlines once you get that letter. Once we respond to the Department of Health's request for additional information and a request for statement, a couple of things can happen. And as far as the timeline of when those things happen, there's really not a great rule of thumb. We've seen it again in recent years take several months, but one of two things happen. Either the Department of Health comes back and closes the investigation with no action, which is obviously what we hope for and what we prefer. They will issue a statement or a letter indicating as such, and then the case is essentially closed, unless there's a request for reconsideration. Or alternatively, the Department of Health can take action if they find that there's sufficient basis to conclude that there's been unprofessional conduct. And those actions can consist of either issuing a statement of allegations and a statement for informal disposition, or a statement of charges. And for those of you who have not been involved in that process, statement of allegations is just how it sounds. It's a document with a series of allegations that have been after the Department of Health's disciplinary authority or disciplinary body has looked at all of the evidence and all of the information that they've gathered. They put together a statement of allegations to support their finding that there's been unprofessional conduct. So they'll put together a statement of allegations, and then they'll put together a statement of informal disposition, which is essentially, to draw an analogy to the legal process, like a settlement agreement that includes terms and conditions for the license holder to consider in lieu of getting a statement of charges. And those terms and conditions that are contained in a statement of informal disposition, or as we call it, a STID, can sometimes be negotiated, and they can be broad in their in their range of severity, anywhere from paying a fine or civil penalty to taking additional CME credits to potentially some summary suspension of a license for a period of time, or restriction of a license for a period of time. It can also include things like enrolling in a substance abuse program that is contracted through the Department of Health if there's a substance abuse issue. So it can be a wide range of terms, but the statement of, or the STID, the statement of informal disposition, will outline those types of terms. And there's an process by which those terms can be negotiated directly with the Department of Health. Sometimes they are willing to negotiate things, sometimes they're not. It just depends on the investigator and who's and the attorney who ultimately issues the STID and the statement of allegations. Alternatively, there's the statement of charges. Oh, I should say one more thing, sorry. With the STID, typically there's a provision in there that basically states the license holder does not admit any of the allegations. So therefore, there's a neutrality aspect to it. The statement of allegations and the STID still get published though, and that's part of the public record. I think one of the most common questions I get asked by our clients are, how can I prevent a STID from being discoverable or part of the public record? And the answer is there's no way. They do get published on the Department of Health website, and every time you look up a provider through their provider finder feature, if they've been issued a STID and if they've signed that STID, it becomes part of the public record. Same goes for the statement of charges. Statement of charges is basically similar to the statement of allegations, but the difference is they are, it's a more sort of accusatory document that then turns into a hearing by the board, who is the disciplinary authority for that license holder. And there's obviously a due process implications for a hearing. There was a case that came out several years ago that stated a license holder's license or certificate is a property interest that license holder or certificate holder has, and therefore their right to due process has to be protected in this context of a hearing if there's going to be a restriction or a revocation or suspension of that license. And so there's a full-blown sort of mini trial or hearing for that license holder to have an opportunity to defend whatever statement of charges indicate were as far as unprofessional conduct goes. And then the authority, the disciplinary authority or the disciplinary body issues a decision, and then there's obviously a right to appeal that decision by the license holder. And then the Washington Medical Commission has put together, I don't know if any of you have seen this flow sheet before, but it's on their website. Washington Medical Commission obviously is the disciplinary authority or disciplinary body for physicians and physician assistants here in Washington. And they've sort of put together this flow sheet of the life cycle of a disciplinary action and investigation for physicians and PAs in Washington that kind of outlines what I've discussed.
And as I mentioned, that the Department of Health also has rulemaking authority, and one of the things that under that authority it has done is creating reporting requirements. So the Secretary of Health has adopted rules requiring every license holder to report to the appropriate disciplinary authority, whether it's a board, a commission, or the department directly, if certain instances occur. These include any conviction or determination or finding that another license holder has committed an act of unprofessional conduct, which, as Aida mentioned, is statutorily defined what specifically unprofessional conduct is. And reporting is also required if there is an indication that the other license holder may not be able to practice their profession with reasonable skill and safety to consumers, patients, or clients in this case. So if there is a concern of consumer safety, then it has to be reported. And the next slide will discuss more in detail what that constitutes. So again, a complaint can be filed by either a patient or a client, but there are certain instances where a license holder is required to report their colleagues, essentially. And that is if they have actual knowledge of any conviction, determination, or finding that another license holder has committed an act of unprofessional conduct. They're also required to report another license holder if the other license holder's reasonable skill and safety is a concern due to a mental or physical condition, then reporting is also required. There are certain situations where a license holder does not have to report another license holder, and those include if they are a member of a professional review organization. And once again, what a professional review organization is defined by the statute. If the license holder is providing healthcare to the other license holder, then they only have to report if the other license holder poses a clear and present danger to a patient or client. So this is a situation where the other license holder is a patient or a client. And in that case, obviously, you would have obligations to them as a patient or a client. So you would have to weigh whether reporting is necessary because they pose a clear and present danger to their patients. And then reporting is not required by a license holder of another license holder if they are part of a federally funded substance abuse program or an approved impaired practitioner program or a voluntary substance abuse program, and they're actively participating in it. If that is the case, then reporting by a license holder of another license holder is not required. There are also situations where the healthcare institution itself is required to report, and that's when a license holder's services are either terminated or restricted because a license holder has harmed, so a harm has actually occurred, or placed at unreasonable risk of harm a patient or client. Another instance where healthcare institutions are required to report is when the license holder poses an unreasonable risk of harm to a patient due to a mental or physical condition. So that's the same for license holder reporting other license holders as well. And then outside of healthcare institutions, reporting is also mandatory by employers of license holders, and that is the case if the license holder's services have, again, been terminated or restricted based on a final determination by the employer of unprofessional conduct. And those are the situations where reporting is mandated by statute. There are also situations when a license holder has to report themselves to the department, and that is when they have committed unprofessional conduct. They're unable to practice safely due to a mental or physical condition, and they have an obligation to report that to the department themselves. They have been disqualified from participating in federal Medicare or Medicaid program, or if they have been convicted. If there is a conviction against them, then they have to report that conviction to the Department of Health as well. If a patient has been harmed because of their practice, then they have to report that too. And all of those reports have to be made within 30 calendar days of actual knowledge. I also wanted to discuss alternatives to reporting to the Department of Health. And that includes Washington Physicians Health Program, which is for licensed physicians and physician assistants. It's a nonprofit organization that is contracted with the Department of Health. And a license holder, their employees, and healthcare institutes can fulfill their reporting obligations by reporting the conduct to Washington Physicians Health Program. There are two specific exceptions. It will not meet the mandatory reporting requirements if there has been allegations of sexual misconduct, or if there is knowledge that a patient's harm stemmed from impairment. In those situations, the Department of Health should be reported directly. There are also resources provided by the Washington State Board of Nursing. So the Washington Health Professional Services offers a range of different programs for nurses. It offers monitoring that is aimed to safeguard the public through the recovery process of nurses. And it can be a possible alternative to disciplinary action as well. There's a ton of other substance abuse and mental health services available, including national helplines that offer family therapy, and a lot of other resources that can be looked into as well. And then there are sanctions for failure to report, which are pretty significant, given that reporting is mandatory. It can lead to a civil penalty of up to $500. And importantly, it can also constitute unprofessional conduct in itself, that either there was no self-reporting when it was required, or there was no reporting when it was mandated, which means that the Department of Health can initiate an investigation based on the failure to report itself. It can also lead to malpractice claims, so there can be civil liability there as well. It's important to note also that there is the person reporting is immune from civil liability if that report is made in good faith. So even if the report ends up being false, there is civil liability available there. Another thing to note is that a lot of the times not reporting when it's mandated may actually harm the license holder, because they can be provided treatment, and the failure to do so can prolong the harm that is resulting. So that's another thing to consider. And then there's specific sanctions for when the Department of Health or the board of the commission finds that a professional has committed unprofessional conduct. And the goal of those sanctions is to essentially protect the public and, if possible, rehabilitate the license holders. It's a tiered approach, and the Department of Health has to follow that approach unless it does not adequately address the specific facts of a given case. There are mitigating factors and also aggravating factors in terms of which sanctions are imposed, and those range from the patient's background, the patient's age, vulnerability, frequency of misconduct by the license holder, motivation of the license holder. So it's pretty comprehensive and case specific as to what sanctions are imposed. Permanent revocation may be imposed, but there has to be a determination by the Department of Health that the license holder can never be rehabilitated or can never regain the ability to practice safely. So they pose a threat to the public if they practice, and permanent revocation is possible then. Aida also mentioned summary suspension. So Department of Health may take emergency action, ordering summary suspension of a license holder or restricting their license pending a proceeding. There are also instances where suspension is automatic. So if the practitioner is certified by the Department of Social and Health Services and then is reported to the Department of Health for non-compliance with a child support order, the license suspension is automatic. And and reinstatement is only possible if the DSHS issues a letter stating that the practitioner was actually in compliance.
Okay, so we're gonna talk about a couple of cases exemplifying some of the topics we've discussed today. Unfortunately, there's not a ton of published cases about reporting requirements because, as I said at the beginning of today's presentation, the Washington Administrative Code that governs reporting is relatively new. And therefore, there's not a ton of case law out there about it, but these two cases hopefully will put some of these concepts into context. So I think you pronounce it Alsager. I'm going to go with that. The Alsager versus Board of Osteopathic Medicine and Department of Health involved Dr. Alsager, who was an osteopathic physician. There had been a complaint lodged against him for improper or inappropriate prescribing practices of controlled substances. That was investigated and a statement of charges was issued. Dr. Alsager had a hearing, and the Board of Osteopathic Medicine ultimately concluded that he had committed unprofessional conduct and that his prescribing practices were concerning. And they issued an order prohibiting him from prescribing Schedule II or Schedule III controlled substances until he completed an approved residency or pain management training course. And that order was had a series of stipulations or of terms that he had to meet before the condition on his license would be lifted. Then subsequently in 2012, just 4 years later, the board received another complaint regarding his prescribing practices for substantially similar claims as the complaint and the investigation previously. So the board sent Dr. Alsager a letter and said, requesting records and requesting a statement from him about his prescribing practices and the allegations about his prescribing practices for that particular patient. Dr. Alsager refused to comply with the investigation. He did not respond to the department's request for records. He did not produce any of his medical records or charts, nor did he issue a statement. Instead, he essentially evoked his Fourth and Fifth Amendment rights, protecting him from self-incrimination, and refused to cooperate. And as I said earlier, these letters that the Department of Health and their disciplinary authorities issues require compliance by a certain date. And if the provider, the licensee holder, doesn't comply by that date, that deadline, or fails to cooperate in the investigation, the failure to cooperate in the investigation in and of itself can constitute unprofessional conduct. And so the Department of Health did their own investigation based on the information that they could obtain, including they obtained records from the pharmacies, the various pharmacies where the patient was filling their prescriptions. And they also obtained records from the PMP, the database that the Washington Department of Health maintains for controlled substances. So they were able to substantiate the claims that the complaint included by obtaining records from various sources outside of Dr. Alsager's lack of cooperation. The board held a hearing on the merits of the charges and essentially determined that he had committed unprofessional conduct by repeatedly violating his order, the 2008 order, while those conditions had not been met and while the restrictions on his license had not yet been lifted, and by refusing to cooperate during the investigation. And therefore, they permanently revoked Dr. Alsager's license. Dr. Alsager appealed the board's final order, and the decision on the appeal was essentially twofold. Number one is that Dr. Alsager was claiming that the board's investigation and resulting hearing amounted to a quasi-criminal investigation, and therefore he had constitutional protections against self-incrimination, which the court disagreed with and concluded that the revocation of a physician's license was not sufficiently criminal to require the protections or the application of the Fifth Amendment protection against self-incrimination. Basically, concluding that a license holder must or is compelled to cooperate with the Department of Health and their disciplinary authorities' investigations. And then second, that involved whether Dr. Alsager should have been compelled to produce the requested records by the Department of Health, claiming that that was an unreasonable search and seizure, again, in the sort of criminal context, or this argument that this was a quasi-criminal investigation, which the court also disagreed with, and also determined that because the board was able to search the PMP database, as well as obtain the patient's or the physician's records from the pharmacies directly, there was no violation of a constitutional right against Dr. Alsager or obtaining his medical charts. Therefore, the final order permanently revoking Dr. Alsager's license was affirmed. So the major takeaway for that case is always cooperate with the Department of Health's investigations. And then the second case we can talk about is the Farzad versus Department of Health case from 2019. Dr. Farzad was a psychiatrist who had been reported to the Department of Health and the Associated Board for unprofessional conduct. He had been specifically reported of some boundary violations with 2 of his patients. And it says MQAC here, which is the Medical Quality Assurance Commission. That's the former name for the Washington Medical Commission. That's what it's called now. It's the disciplinary body that governs or that regulates physicians and physician assistants. So those terms are interchangeable. They just changed their name, I think, in 2019 around there. But at the time of this case, they were still referred to as MQAC. So Dr. Farzad actually did not deny the allegations that were contained in the letter and in the subsequent statement of allegations, but his argument was that they were appropriate and did not amount to unprofessional conduct. So MQAC pursued a statement of allegations, a summary of evidence, and a STID. And while the negotiation process was pending, or while that STID was pending, MQAC learned that Dr. Farzad had been arrested for making telephone threats to Molina Healthcare which he had never reported. And allegedly, he had been arrested because he had been calling Molina Healthcare, and who's his employer at the time, and alleging or making threats that he was going to bomb the place or kill the people who worked there. So 911 was called and he was arrested. Based on the arrest, obviously constituting unprofessional conduct, I mean criminal conduct, the MQAC panel summarily suspended Dr. Prasad's license pending a hearing, which again, he was entitled to a hearing because of his due process rights and property interest in his license. At the hearing, again, Dr. Prasad did not deny any of the allegations that were raised. And ultimately, the MQAC determined that the conduct was indicative of an underlying mental condition, which rendered him unable to safely practice. And MQAC actually, in their order, drafted sort of a summary of why they felt suspension was necessary in this case, which I'm going to read to you from the order because it's a great description of what went on. But it says, the ongoing inability to practice with reasonable skill and safety issue in this case can be seen in regular conversation with the respondent, being Dr. Prasad, and was clearly apparent to the commission. It is the manner in which Dr. Prasad attempts to dominate and manipulate everyone with whom he interacts in a constant effort to gain their attention and admiration, whether it's through his grandiose presentation of self, his misleading and hyperbolic answers, his contemptuous and impatient dismissal of others, blame shifting, launching into lengthy stories that overestimate his accomplishments or abilities, or his flagrant attempts to control every discourse to prove his superiority. The respondent's demeanor and presentation during his testimony was simply and fundamentally manipulative, controlling, and grandiose, and indicates some type of underlying mental condition that does interfere with his ability to practice as a physician with reasonable skill and safety. So quite the description, but ultimately they suspended his license and ordered him to undergo a neuropsych evaluation and enroll with the WPHP that Bisma talked about. And while he did obtain a neuropsych evaluation, he had some compliance issues, and ultimately after the WPHP investigated and met with Dr. Prasad, they determined that he was not, they determined that he was not fit to continue practicing medicine, and they did not recommend reinstatement of his license. Dr. Prasad filed a civil complaint against MQAC, now known as the Washington Medical Commission, the WPHP, and Molina. And he claimed gross negligence, civil conspiracy, disparate treatment, unlawful retaliation, negligent intentional infliction of emotional distress, libel, slander, etc., defamation. And summary judgment was granted on behalf of all of the defendants in that case based on the immunity. So all of these governing bodies have immunity as far as civil damages goes. So key takeaways from today as far as DOH investigations and reporting. Number one, always cooperate with DOH investigations. Keep in mind the timelines and the deadlines for those investigations, and make sure you comply with them. In my experience, it's okay to ask for extensions. but do so as soon as possible so that you can ensure compliance with their requirements and with any requests for production of documents or statements. Number two, mandatory reporting applies only to actual knowledge of unprofessional conduct or issues of mental and physical fitness. So it's not enough to just believe or assume or hear rumors of unprofessional conduct or fitness issues. You have to have actual knowledge of those things. Number two, if you're a healthcare institution or a hospital, conduct your internal investigations in a timely manner, because the reporting requirements don't kick in until a final determination is made, as long as that final determination and finding is made in a timely manner. And then number four is failure to report, including self-reporting and reporting by employers, may be subject to civil penalties. So really important to know what those reporting requirements are and the timelines for those. And with that, we'll open up the floor for questions if anyone has any.
Well, thank you so much, Aida and Bisma. We did have a few questions in the chat if you are ready for them. The first one is, what if the provider is contacted by the Department of Health or Washington Medical Commission and requests a meeting or phone call with the investigator? No letters have been sent from the Department of Health or Washington Medical Commission. Does the provider have to meet with the investigator?
Great question. So if I understood the question correctly, it's the Department of Health has issued a notice letting the license holder know that there's been a complaint and has requested to meet with the license holder. If that understanding is correct, typically what we would say, you definitely want to cooperate with the investigation to the full extent possible. Know that anything that you say to an investigator or any statements that you make to an investigator may be recorded or may be transcribed. So there will be a recording of it somewhere, somehow, that can then become subject to public disclosure. So just it's while you have to definitely cooperate with the investigation and cooperate with the Department of Health's requests, you do so cautiously. And in that instance, my advice, though bias, would be to retain counsel so that counsel can prepare the license holder for that investigation, for that meeting, for that discussion in advance of whatever statement the Department of Health is seeking.
Is an ROI required to release records to the Department of Health?
Generally, no. There's a statute or a Washington Administrative Code specific to basically a HIPAA exception to government agency investigations. It gets a little bit tricky with treatment records relating to psychiatric or psychological treatment, but generally the answer to that is no.
And I think this question refers to an earlier portion of your presentation. The question is whether the $20,000 threshold for the portion is attributed to the provider. Example, $100,000 is the overall settlement, 100% goes to organization, or $190,000 goes to the organization and $10,000 goes to the provider.
Ooh, that's a good question. From my memory, the statute specifically states that the settlement has to be over $20,000, in excess of $20,000. But it doesn't define whether that settlement is global or individual. So I'd have to do a little bit of research on that to see if there's any guidance on specifically if it has to be a global versus individual settlement, but erring on the side of caution, I would, if the global settlement is in excess of $20,000, then that reporting requirement would be triggered. But I have not encountered that issue, so there might be some guidance out there. I can, if you want to email me separately, I can do a little bit of digging and see if there's any specific guidance on that.
And since we're reaching the end of our hour, I just have one last question that you can answer. The rest, if anyone has any additional questions, I'm happy to provide Aida's or Bisma's email, and you can email them directly. This last question is whether the 30-day requirement for reporting, for self-reporting, is only for all types of reporting, including employer, hospital, etc.
It depends. Each of the various reporting requirements and the timelines relate to the type of organization doing the reporting and the type of report. So some are 30 days, some are 20 days, some are 60 days. So it really depends on the situation and what the who the reporter is and what they're reporting.
Well, thank you both so much. We really appreciate all of the information provided in today's presentation. If anyone didn't reach out to me directly and their name and email address was not easily apparent in your screen name, please email me at talia@foxballard.com if you're interested in getting CLE or CE credit. Thank you, everyone. We really appreciate it.